All right, it sounds like we're live. Chair?
All right, this is Chair Douglas, the Cannabis Compliance Board, State of Nevada will begin now. If we can have a call the roll of the board members.
Great, thank you. Member Merritt?
Here.
Great. Member Nylander?
Here.
Member Durrett?
Here.
Member Young?
Here.
And Chairman Douglas?
Here.
Great. Deputy Bala, can you please confirm that we've complied with the open meeting law requirements? Deputy Bala, can you hear me? I believe he's joined.
Yes, sir. Can you hear me?
Yes, we can.
Yes, we are in compliance, sir.
Thank you. Well, great. Chair, with your approval, I will get started by introducing agenda item 1, which is public comment.
Please go forward.
Okay, great. We have not received any public comment for today's meeting, so we will move on to agenda item 2, meeting minutes.
And the minutes were provided. And if the members have had an opportunity to review them, if we can get a motion for approval and or any corrections that needed to be made.
Mr. Chairman, this is Member Nylander. I would move for approval of the minutes of November 17th as outlined on the agenda for today.
Thank you. And can we get a second?
This is Member Jerry Merritt. I approve for a second. Move for a second.
Thank you. We have a motion for approval with a second. Any additional discussion? Hearing none. All in favor of approval, please say aye.
Aye.
Aye. Been passed unanimously. That will move our agenda down.
Great, thank you, Chair. Next agenda item number 3 is the request for transfers of interest. Dave Staley, Chief Investigator for the CCB, will present this item via Zoom. Chief Staley.
Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. Good morning. For the record, I am David Staley, Chief Investigator for the CCB. I'm here to present item number 3, which consists of 8 transfer of interest or TOI applications. Mr. Chairman, with your permission, I would like to present the last 4, E, F, G, and H in reverse order to the way they're agendized. So we would go from D to H, then G, F, and E. I think that would be the appropriate sequence of evaluation, and if the board does approve those TOI applications, they'll be done in order.
That's fine.
Thank you very much. Agenda item A is the TOI application for Lone Mountain Partners LLC, or Lone Mountain. TOI number 21010 was filed by Lone Mountain to clarify its organizational structure as approved by the Department of Taxation on June 30 of 2016. On June 30, 2016, the Department of Taxation approved a TOI in which 100% of the ownership of Lone Mountain was transferred to owners Samuel Dorff and George Arcos. However, that approval failed to include approval of the intermediary company that Dorff and Arcos held their ownership through, Nevada Natural Treatment Solutions, LLC. The intermediary company had been identified in the 2016 application, but was not formally reflected in the approval. Lone Mountain has filed TOI number 21010 to assure that approvals from the CCB accurately represent the actual ownership of Lone Mountain. In effect, this is an administrative TOI to simply clarify our records. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Kimberly Maxon Rushton is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Let's find out if any of the board members have any questions before we decide whether or not we need to hear from the attorney. Any of the board members have any additional questions? So Mr. Staley referenced his report. Hearing no additional questions, if we have no questions, can we have a motion for approval of this item? And we have no conditions to be suggested as to this matter.
Mr. Chairman, this is Member Nylander. I would move for approval of the Lone Mountain Partners, item number 3A, as stated on the agenda.
Thank you. And if we can have a second.
Member Durant, for the record, I second.
Thank you. We have a motion. We have a second. Any additional questions or concerns? Hearing no discussions, all in favor, please say aye.
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 Motion's been carried unanimously. Mr. Staley, you can move along.
Thank you, Mr. Chairman. Item B is the TOI application for Planet 13 Holdings, Inc., or Planet 13. TOI number 20017 was filed by Planet 13 to include the transfer of distributor's license T077 to the approval that it received from the CCB at its August 25th, 2020 board meeting. In August, the CCB approved the transfer of cannabis cultivation licenses C067 and RC067, as well as cannabis production licenses P034 and RP034 from West Coast Development LLC, or West Coast, to Planet 13 pursuant to an asset purchase agreement between the two companies. While processing the approval letters to be sent to the companies after the CCB meeting, CCB staff discovered that West Coast also held distribution license T077. Both Planet 13 and West Coast informed CCB staff that T077 was included in the asset purchase agreement, but that both companies had overlooked it while submitting the TOI application. As a result, Planet 13 has filed TOI number 20017 to request specific approval for the transfer of distributor's license T077 from West Coast to Planet 13. In addition, Planet 13 has requested a waiver pursuant to NCCR 5.112 of the requirements of NCR 5.110 regarding a review of all Planet 13 owners. Staff identified no areas of concern with this application, and again, it's largely an administrative transaction to clarify our records. I am available for any questions, and my understanding is that Leighton Kohler is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. We have a report. Board members, any questions of Mr. Staley as to Planet 13 Holdings report and proposed action?
Mr. Chairman, this is Member Nylander. I have just a quick comment, not a question, but I just wanted to say that I'm pleased with the way the reports are being generated, especially the waiver provision, which we've dealt with on a number of occasions for less than 5% owners. And I think that process is now working very well. And so I just wanted to make that comment for the executive director and the staff that I think that, when we all first sat down here, it was a difficult thing, and we kind of unwound it and rewound it, and now I think it's working pretty well. So just a comment, Mr. Chairman. I don't have any questions.
Thank you for that comment. Any other comments or questions?
I second that comment.
Well, Mr. Chairman, I'll make a motion if Rihanna wants to second it.
Please go forward.
Yeah, Mr. Chairman, I would move that we approve this agenda item regarding Planet 13 as it appears on the agenda.
And Mr. Staley, you said we needed to also have a condition as to the 5%, less than 5?
No, Mr. Chairman. The waiver pursuant to 5.112 is in relation to this transaction specifically. The additional waivers pursuant to NCCR 5.125 I have included specific conditions relative to those waivers, but NCCR 5.112 waivers are transaction specific. So the waiver will, I guess, occur up to the point where the board takes action on the application and then is no longer needed.
So in essence, we do not need a waiver attached to our motion at this point.
I'm sorry, Mr. Chairman, I didn't.
We don't need any conditions.
No, sir. There are no proposed
Okay.
conditions associated with a 5.112 waiver.
Okay, thank you. You mentioned something earlier and it just kind of caught my ear. We have a motion then for approval. We need a second as to Planet 13 Holding. It's TOI request. Can we have a second, please?
Member Durrett, for the record, I second.
Thank you, Member Durrett. We have a motion second. Any additional discussion? At this time, all in favor, please say aye.
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 Aye. Motion carries unanimously. We can move our agenda along.
Thank you, Mr. Chairman. Item C is the TOI application for Nye Farm Tech Limited, or Nye Farm. TOI number 10773 was filed by Nye Farm requesting approval for various internal transfers to be completed, which would ultimately result in 4 existing members transferring their membership interest in Nye Farm to an intermediary owned by 3 other existing members, Sandy Orr, Sophie Eidecker, and Rick Saga, and 1 existing member gaining additional shares for forgiving a $70,000 loan to Nye Farm. After completion of the proposed transactions, Sandy Orr, Sophie Eidecker, and Rick Saga would own 93% of Nye Farm through the Healing Center LLC, and David Brocksterman would own 7% of Nye Farms directly. Staff identified areas of concern with TOI number 10773 because the various transfers of interest occurred before Nye Farm sent its TOI applications to the CCB. Apparent violations of NAC 453D 315, which was in effect at the time of transfer. In addition, board staff began its investigation into this TOI application during July of 2020, at which time they conducted interviews and requested financial statements. Despite repeated requests for a written explanation of the lack of financial statements and an explanation of the transfers of interest completed without prior CCB approval, the company was unable to provide anything until yesterday, December 17th, 2020. Yesterday afternoon, Rick Saga provided a letter or timeline to CCB staff along with a brief explanation for the delays in providing information. That letter was provided to board members yesterday afternoon as well. CCB staff have provided potential options for the board's consideration to proceed with TOI number 10773, and we have explained those options to Rick Saga as well. I am available for any questions, and my understanding is that Rick Saga and counsel is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Before we like to hear from our licensee or their counsel as to this matter before I turn it over to the board for questions.
Amber, can you please unmute Mr. Saga? Mr. Saga, are you available? Mr. Rick Saga, can you hear me?
Morning, sir. Yes, sir, I can hear you. Good morning.
Morning, Chair.
We wanted to hear from our licensee or counsel as to why we're having the difficulty getting information in this matter.
Let me first introduce myself. Thank you for the time. My name is Anthony Santos, bar number 11265 here in Nevada. I represent Mr. Saga and the applicant. With that said, Rick, why don't you go ahead and explain what the difficulty is in terms of getting all this information.
When we were in September, when by the investigators, when we were asked for P&Ls in the balance sheets in the tax documents, during that time, I had tried to reach my accountant. I have two accountants, and both the accountants were unavailable. One of the accountant has left the country and to Taiwan and has not been able to come back. The second accountant, her name is Suenma, and her sister and her mother both passed away. So due to that COVID thing, so she's not able to produce the documents, but I have all the tax returns that has been 00A1 filed, and we will produce the documents. I'm just having difficulty to get all the documents from them, sir.
There is concern, I will share my concern. There's concern as to getting the information so we can process your transfers and not blindly do so. And I'm concerned about the financials and the ability for staff to be able to review them. And part of the question I have for you is whether or not we can have those in a timely manner prior to our January meeting to see your financials.
Yes, sir. If you give me the time, I'm going to work on it and get it prior to the meeting of the January, all the financials and P&L and balance sheet to you, sir.
Questions of board members, of our licensees, or Mr. Staley at this time? Okay, if we have no additional questions, then we'll return back to the board. I would, looking at the matter before us, I would want to propose that we look at the option of a 30-day conditional to allow them to operate with a conditional TOI approval, subject to them coming on our January agenda with completed information as to the final background. If this is not accomplished, then we'll be looking to not grant the TOI. It would be a 30-day conditional. That would be my proposal. Any other ideas or suggestions by board members?
Member Durrett, for the record, I would just comment that it is worrisome that these records aren't just available for upon demand. Mr. Saga, these records shouldn't be something that you have to track down. You should have them available to the board anytime they inspect.
Yes, ma'am. I do apologize for that, and I agree it should be available with us. But since the nature of the business, we were not able to open a bank account anywhere where we could do this. And this much larger amount of cash, we do not have an excess of cash money to pay anyone. So seeing that, we had kept all our financials to the accountant. What I have is the filings of 00 tax returns, so that after we thought when it would be a legalized action that we can open a bank account straight directly, we would be able to amend it. I have the 00 taxes filed, which are with me, and with the K1s. That's all I have. And I did not realize that for the transfer, right in September when the new board came, we would be required to present the balance sheets and P&Ls and the detailed financial statements. So that is my request to you, that I will acquire that and I will have it for you.
Chairman, this might sound a little silly, but would you entertain, or maybe I would include in a motion, a requirement that the licensee be required to review the regulations?
I think we can. I guess the important part is for them to sit down with our staff and go through this and provide them what the staff needs to give us a report as to their condition And hopefully that can be accomplished prior to our January meeting. And I think they will point them in the right direction as to our regulations.
And if I may, I can assure you that I will make sure or make certain that my client familiarizes himself with the regulations as amended. And I apologize. I just recently got hired for this particular situation, but I can assure you that Mr. Saga and his staff will be familiar with the regulations.
So Member Durrett, you gave us could you repeat? You were throwing out a motion?
Well, I would move to do a conditional approval of the transfer of interest conditioned upon the requirement that the profit and loss statements, the balance sheets, and I think we need more documentation. Actually, I need to know from Mr. Staley, do we need more documentation on the transfer? Because what Mr. Saga submitted said that the transfer hadn't even really occurred, that no interest actually changed hands. So whatever documentation he has on whether transfers already occurred or not, that would need to be included. And then finally, I would condition it on a review with his attorney of the regulations.
And to be done prior to our January meeting.
Yeah, all this would be 30 days or prior to the January meeting, whichever comes first.
We have a motion on the floor. Do we have a second for the conditional approval to January?
Mr. Chairman, this is Member Nylander. I would second the motion, and I also have one additional question.
Please.
Yes, so for the applicants, how specifically do you intend to cure this by our January meeting? I mean, you've mentioned you're going to take care of it. I haven't really heard of a specific plan, and I'm not asking for anything confidential, but if you could expand upon that, it would be helpful for me.
Absolutely. When we started this transfer, the transfer was started in 2017. We were having difficulties with one of 82-year-old gentleman not being fingerprinted and fingerprints not coming in, and it had continued from that day. In September, when we were asked for only 2 items by investigators, was the balance sheets and P&L and the financials for that. We are going to go ahead and give the balance sheets, financials, and the money tracking. How did the money came in through a management company? That is the thing they wanted. I'm going to supply that. In a month of March or before March, we are going to reassess all the 2-year tax returns and submit the 2-year tax returns.
In addition, he's hired counsel and additional accounting staff.
Yes, sir.
To make sure that this material gets submitted in a timely fashion.
Okay, thank you.
We have a motion on the floor. We don't have a second yet for at least a 30-day conditional at this point. And I understand Member Nylander's concerns. I have the same share of concerns about accomplishment, but 30 days would at least put us in a position to determine what the next step should be in January. But we do need a second or the motion.
Mr. Chairman, this is Member Nylander. I would second that motion.
Thank you. We now have a motion and a second. Any additional discussion or comments? Hearing none, all in favor of the conditional approval to our January meeting for the items to be provided that were mentioned in the motion, and for staff to sit down with the licensee, hopefully, and get this worked out. With that being said, all in favor, please say aye.
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 Aye. Motion carries. We have a 30-day. And I would just, the board's concern, hopefully with council and ownership, you'll sit down with our staff members, our agents, and go through this and come up with what needs to be done. Thank you very much. And
Thank
we'll
you.
move.
Thank you, the board members and everybody and the staff and everyone. Thank you so much for giving the opportunity.
Thank you. Mr. Saley, back to you for,
Thank you, Mr. Chairman. Item D are the TOI applications for Green Growth Brands, Inc., or Green Growth, and the Source Holding LLC, or the Source. TOIs number 19041, 19042, 19043, 19077, 20013, 20014, 20015, and 20016 were filed by Green Growth requesting approval to complete the acquisition of Nevada Organic Remedies LLC, or NOR, by purchasing the remaining 5% ownership in NOR from Andrew Jolly, Stephen and Patrick Byrne, Darren Peterson, and Lizel Six, requesting approval for the insertion of 3 intermediary companies in the ownership between Green Growth and its Nevada licensees, and requesting approval for the Source to acquire all of Green Growth's Nevada cannabis licenses. Green Growth is in the final stages of a recapitalization under the Canadian Companies Creditor Arrangement Act, and the Source is comprised of Green Growth's secured creditors. Pursuant to a court-approved acquisition agreement, the Source will acquire all of Green Growth's Nevada and Massachusetts cannabis licenses and assets in return for extinguishing all amounts they have loaned to Green Growth. In addition, Green Growth and the Source have requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. The companies have adequately addressed the items required in NCCR 5.112 and 5.125, including the addresses of each shareholder, to allow the board to approve such waivers. Staff suggests that if approved, the board limit the Source's 5.125 waiver to expire on such agenda date as the Source's next TOI application is heard by the board. Staff identified areas of concern with TOI number 20016 because Green Growth had completed the insertion of its 3 intermediary companies 10 months before it filed its TOI request for approval of such transaction, an apparent violation of NAC 453D 315, which was in effect at the time of the transfer. In addition, Green Growth completed various transactions in which it acquired and issued shares of its common stock without prior approval, apparent violations of NAC 453D 315 and NCCR 5.110. Staff identified no areas of concern regarding the Source. CCB staff have provided potential options for board's consideration to proceed with these TOIs. We have explained those options to Green Growth Council and have included Green Growth's response as an exhibit to our investigative report. I am available for any questions, and my understanding is that Amanda Connor is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
thank you. We'd like to hear from counsel, Ms. Connor, as to this matter and the concerns raised by the board, by our staff members.
Amber, please, unmute Ms. Connor. Ms. Connor, are you there?
Good morning, Director and members of the board. I am here today on behalf of my client, clients, Nevada Organic Remedies, Henderson Organic Remedies, and Wellness Orchards of Nevada regarding the transfer. We have worked for several months with Chief Investigator Staley regarding these various transfers, and we appreciate all the effort of staff in processing these, as it was transfers that had been pending back since May of 2019. My clients understand the concern of the investigator in relation to the intermediary companies. It was a misunderstanding that a pass-through entity that's disregarded would trigger such a transfer. My client did attempt to correct that by filing the notice of transfer, but we understand the concern there. With regards to the stock issuances, as the board is aware and has been diligently working on issuing new regulations or implementing new regulations, for a long period of time, the requirements related to publicly traded companies was not crystal clear. My client is an operator that strives to operate in compliance. They submitted various notices of transfer of interest with relation to each license, had at some point up to 6 for each license pending, and had, tried to be as forthcoming as they could, but they do understand that we are still working through the requirements to publicly traded companies, and appreciate the board's efforts on that. I'm available to answer any specific questions the board may have.
Thank you. With that, members of the board, questions of Mr. Staley or counsel for green growth and the source application?
Mr. Chairman, this is Member Nylander. I have a question first of the applicant's counsel. So I understand that these intermediary companies were established for a number of reasons, I think partially tax reasons, and you mentioned the disregarded entity. But I want to get some sense from the company that they understand sort of where the regulation is coming from. When you establish new companies and insert them in the corporate chain, the state has no ability to know who's in those companies. And so there is a vehicle there for hidden ownership. And that is something that, we want full transparency. And so I recognize the argument that at the end of the day, this didn't change the ownership, but we would not know that if we did not have the regulation in place and licensees did not follow the regulation. So the reason for the regulation is that it prevents hidden ownership, among other things, hidden financial movements. Those are things that are critical to the regulatory structure. And I guess I want to get some sense from the applicant of how they view that.
Member Nylander, Amanda Connor for the record, on behalf of my client. I've had several discussions with my client and the Source Holding, who is the proposed new owner, regarding these requirements. They understand the concerns of the board and the reason for full disclosure, including pass-through entities that have, are disregarded. Like I said, it was a misunderstanding of the requirements, and they apologize, accept that was a misunderstanding, and will not let it happen moving forward. I would also add and comment that they were one of the main prominent members in the retail store litigation that went very well in depth over requirement of ownership disclosures, and so have become very familiar with those requirements. So this was a mistake and something they have learned from and understand the requirements.
And so the company going forward, if you could give me a sense of how that's going to function going forward in terms of compliance.
Member Nylander, the company going forward is a private limited liability company. It will not be publicly traded. It is made up of the secured creditors that are coming forward, and they're as a part of the bankruptcy filing in Canada, the CCAA filing. They have team members here in Nevada that will be running the operations. In fact, on the Zoom call today is Brandon Wigan, the compliance officer that will oversee all of Nevada operations. I will remain on as the regulatory compliance counsel. And several of the members of the source holding are actually the original owners of these companies that applied for the medical licenses in 2014, including Andrew Jolly, who served as president for the Nevada Dispensary Association for several years. And those members helped with development of the program and the industry. So they're familiar with Nevada requirements, and they are going to be involved in the operations.
And it appears from the records we have that those individuals did operate the business successfully previously.
Yes, I believe they had a may not be flawless record, but they were a good compliant operator.
Okay, and so as a result of the I guess the reorganization under Canadian law, they were the secured creditors that had priority, and so they'll now receive the equity.
They are some of the secured creditors. There are others, as has been fully disclosed to the board and Investigator Staley. But yes, some of them are secured creditors coming back.
Thank you. Well, one further question was, and again, I understand that these transfers occurred previously, and maybe this is for Mr. Staley, but was there any issues with some of these public offerings that occurred under Canadian securities law? Or were they done, did they appear to be done in compliance with Canadian securities law?
Member Nylander, Chief Staley for the record. In review of the secondary offerings that the company completed, they appeared to all be in compliance with Canadian securities laws. I might add as well that even the largest of those transactions, which would have been the repurchase and cancellation of 27 million shares, was well below the 5% threshold that we review. It was only about 1.7%. So the staff's concern is that there were transfers and the company had not yet taken advantage of the 5.125 waiver, which they have rectified with this TOI application.
Thank you for that.
Any other board member wish to weigh in at this time?
Questions about the stock transfers. So, because there's two separate issues here. There's the intermediary company, and then there's the stock transfers. I guess the first question is for Mr. Staley. The concern about the 5 or 6 stock transfers occurred before the NCCR were adopted, right?
Member Merritt, Chief Staley, no, ma'am. 3 of the stock transfers that I identified in the investigative report were issued or concluded under the NAC. 2 of them were completed under the NCCR.
Okay, thanks. And we don't know exactly how the ones that were completed under the NAC would have been processed, right? Because Department of Taxation didn't have a process set up yet, right?
My understanding, Member Durrett, is that after the extended review period was put in place, and especially in the context of the ongoing litigation, I don't think taxation was comfortable in its ability to handle publicly traded companies. When everything was placed on hold, a lot of those holds were specifically because they did involve PTCs. So I think it was a lack of clarity in the NAC, as well as the Department of Taxation's ability to process those. The CCB, when we helped put together new regulations to support the new statutes or the NCCR, we tried to address those as best as possible. So I would agree that the landscape regarding PTCs and secondary offerings was unclear both from the regulatory side and the licensee side prior to the NCCR becoming active on August 5th of this year.
For any of the transfers that are mentioned in the report, did any of those occur after that August 5th date?
Yes, ma'am. One occurred on August 22nd of 2019, and the next occurred on, well, that wouldn't work, would it? No, they all occurred before August 5th of 2020. So I was mistaken. None of them occurred under the NCCR. They all occurred under the NAC, which would have been the period of time that things were not clear at all.
Okay, thank you. And again, to echo Member Nylander's comments earlier, these reports are, and the work you guys do is incredibly helpful. I think on this one, with these stock transfers, I don't think the industry and the regulators were on the same page with what the stock transfers, what was allowed and what wasn't, because I'm just now gaining this understanding through reading these that the stock transfers between shareholders, for example, 1% shareholder sells his stock to somebody else, that is treated the same as a capital raise, for example. So, and the company selling off stock. So I think there has been a lack of clarity on stock transfers and related matters. And I think we really need to clarify what those rules are going forward and get a more, get an understanding from everybody to get on the same page.
Additional comments by board members or questions?
Mr. Chairman, this is Member Nylander. I agree with Member Durrett's comments. In looking at the totality of the record, it appears that their Department of Taxation was providing some sort of advice, but it was very nebulous, at least in terms of what was necessary. And I think in this case, the licensee did, at least on some level, try to comply, although I'm concerned that the TOI application came some 10 months after the transfers occurred. But I am somewhat sympathetic to that. But I do think that with the new regulations that are in place, there is a lot more clarity. And once again, we're dealing with a legacy issue that occurred before the new regulations were in place, and in some instances before the old regulations were actually being enforced at all. But on a go-forward basis, and this might not apply to Canadian companies, but there is a mechanism in Nevada law which recognizes the United States Securities and Exchange Commission's regulations, where when a company is issuing new securities, there are approval requirements, disclosure requirements, a number of things. But there's also a mechanism called a shelf approval, where the company can apply to the regulator, both federally and locally, meaning us in Nevada, for essentially a shelf approval to allow continuous public offerings without any additional approvals. And it runs over a 2 to 3 year period. And so it's a continuous approval. So it's granted once, and then the licensee can do whatever they need to do financially, and it's just a reporting requirement. So I guess I would like to consider maybe at a future meeting, and I'd like to get comments from Mr. Staley on this, but that we might consider that as a mechanism to deal with continuous and stock offerings that occur with public companies. It's part of their daily sort of thought process. So our current regulations don't really contemplate that, but this particular case has raised the issue in my mind that maybe that's something we should pursue. And Mr. Staley, I don't know how that would work with Canadian companies, because we do have a number of large Canadian companies, but I assume they have some mechanism to do a shelf approval for continuous or delayed offerings. Mr. Staley, does that make sense to you?
Yes, sir, Member Nylander. I believe, and I don't have them right in front of me, but I believe the statutes that cover cannabis regulation set the threshold at 5% and above, or less than 5%. As a result, I don't know if a shelf or continuous or delayed public offering would apply in all cases. For example, if a secondary offering ended up in the issuance of more than 5% of the shares. When we were putting together the NCCR, we wanted to kind of put in place the flexibility of a continuous or delayed public offering or shelf option. And we tried to address that with NCCR 5.125, which in effect was a waiver of the requirement of any shareholders or owners under 5% from needing an agent card or needing a TOI approval. That now, in the case of an executive card where you have a member manager or executive of a company that also owns less than 5%, those individuals would still need an executive card. But for all members that hold less than 5% and for issuances that would be less than 5%, we felt that that could be addressed with 5.125 without conflicting with the requirements of the statutes. I'll point to the Mystic Holdings application, which is next on the agenda. They were able to use a Regulation A filing, and there were certain limitations there dealing with the amount of shares that they could issue, which matched with the ability to stay below 5%. I guess my conclusion is that I believe we would need to have changes to the statute to allow a shelf, but it's certainly something that staff will review and see what we can do.
Thank you for that. And Mr. Chairman, I apologize for kind of veering off of the direct application, but this application has, brought those sort of thoughts to my mind. And I think at the end of the day, this is an evolving process, as you've said, Mr. Chairman. And, I think our concern is always going to be control. And when there's an issuance of new stock, is it going to affect control of the company in some way? And I think in this instance, these were, these issuances of stock were for financial reasons, and they didn't seem to have any control issues. But and I'm willing to, if we put this on the agenda for a further discussion at some other time, I'm willing to sort of drill deeper down into that. But thanks for allowing my questions, and I apologize for veering away from the facts, but I guess I would go back to Ms. Connor. These issuances and reissuances of stock that are detailed in our report, were they intended in any way to affect control of the company?
Member Nylander, no, my understanding is no, it was not. It was related to some financial, issues, stock buyback or issuance of shares. As Chief Investigator Staley commented they were done in 2019 and it was less than 5%, it was affected of the shareholders, or percentage less than 5%. Therefore, and to one more thing, the companies did apply for the waivers prior to this transfer being submitted shortly after the waiver process came out with the adoption of the regulations that went into effect in August. Just to put that on the record, that they did attempt to comply once that process came forward.
Very good, thank you. And Mr. Chairman, I'll shut up for a while.
Mr. Chairman, this is Chief Staley again. Just wanted to apologize to the board. On the 5 instances that I identified on page 23, I wanted to clarify all of those occurred under the NAC, not the NCCR like my report indicated. I think I was looking at the months, not the year. I apologize. So just to clarify, all potential violations under transfers of interest occurred under the NAC, none occurred under the NCCR.
Question for you, Mr. Staley, this is the chair. Looking at this, I think it would be appropriate that we approve. The only concerns I have, though, is going back to what's been discussed, and that is under transparency and the failure to provide the information as to intermediate companies in a timely fashion, and the stock, whether or not, in your opinion, even under the conditions, was that something that from our standpoint should have been done? Because I'm trying to look at what would be appropriate to approve today and whether or not this should be possibly referred out to look at for possible violations, or conditioning it with some type of monetary sanctions, if that's acceptable to the licensee, for failure to give us the intermediary transfer situation and the stock information.
Mr. Chairman, in my review of the past approvals and TOI applications conducted by the Department of Taxation, I believe that a precedent had been set that intermediary companies should have required a TOI application for the transaction that they did. However, I also recognize that there was a great deal of confusion at that time and not necessarily a lot of clarity. I will point out that the applicant did identify that the insertion of those intermediary companies had occurred and filed the appropriate TOI applications, although about 10 months after it had occurred. Do you want a suggestion from me on what I think is appropriate, or were you asking an opinion on that?
I'm looking at an opinion from a standpoint of whether or not these, in your opinion, and like I said, we have options of finding technical only and doing nothing at this point, referring back to staff to really dig in and say whether or not these are violations, or in light of discussion today, saying we think that there were technical violations and there's a minor monetary sanction that would be recommended. Whether it's accepted or not by the licensee is a different story, but we have the 10-month delay, which clearly, it seems clearly that we have a problem with that. The stock transfer, you seem to saying that's in a gray area.
Mr. Chairman, I believe, in summary, the insertion of the intermediary companies, I believe, was a clear violation. I also believe that they were not conducted on purpose by the company. I think it was an oversight. From my review, I agree that any secondary offerings occurred during a gray period and also during a time at which it was difficult to get clear guidance from the Department of Taxation. In total, I believe that condition number 4 of the investigative report on page 25 may be the most appropriate. I believe when we calculated a recommended monetary fine, that was based on the totality of both the intermediary companies and the secondary offering. Based on discussion here, I think that the secondary offerings may have occurred during a gray period, and as a result, I believe it may be appropriate to maybe look at that dollar fine and adjust accordingly, depending on the board's position on this matter.
All right, thank you. I don't know where the other board members are. I, for one, would condition approval of TOI on the stipulated agreement of green growth and the source to accepting a civil penalty. And I'm looking at a dollar amount of about $25,000. If that's acceptable. If not, the option would be to refer it out for the staff to refer to the Attorney General's office to look at if there is in fact violations that we should proceed with. But I'd like to hear from the licensee, Ms. Connor. And I appreciate, Ms. Connor, your intervention in this matter. I was concerned by the letter we got from Green Growth Brands and their position at the time. So, Ms. Connor, I don't know if you have authority or whatnot today, or whether you'd have to talk to your licensee as to this matter.
Good morning, Chair. I thank you first for recognizing my assistance and stepping in. I'm hoping, that we, my like I said, that my client's message that they intended to comply, and that it was a gray area, and we would appreciate, as Member Nylander suggested, for clarification, although stock offerings will no longer be applicable to this client, I know for the industry in whole, additional clarification would be well. I do have authority from my client to accept a fine of $25,000 if the transfer will be approved.
Thank you. Any other board member wish to comment or query at this point or express a view?
Mr. Chairman, this is
Go ahead.
Board Member Nylander. I would support moving forward and approving the transfer of interest as it's been outlined, and with the additional, the Attorney General's office would work and our staff would work with them to come to a stipulated agreement. And the $25,000 I think is probably consistent with prior matters with respect to the intermediary company issues. So I would be supportive of that, and I do believe that we should move forward today because in some respects, these secured creditors are the ones who are going to wind up with this license. And as Ms. Connor has indicated, they have prior experience before all these financial problems beset this company. And I think in fairness to those creditors and the process they've been through under Canadian law, that that it's in the best interest of our state to move forward and go ahead and finalize that by allowing the transfer to occur.
Okay, we have a motion. We need a,
Chairman, may I comment before we go forward?
yes, please.
I just wanted to comment that I agree with your approach. I also had hesitation about the letter, the way it expressed, well, we filed this. It didn't point out that it was 10 months later that they had filed it, and it didn't point out, and then it said, but taxation never did anything about it. There was a moratorium on transfers. The industry needs to accept that. I have a feeling we'll be seeing a lot more of these issues, and the fact is there was a moratorium. Here, the way Ms. Connor explained it, which makes a lot more sense, is that it was discovered and then basically self-reported when they submitted the transfer request. So I think it does make sense to be to take those into account as mitigating factors. Thank you.
Chair Douglas, this is Chief Staley. So we've kind of drifted off a bit from the 5.125 waiver. I just wanted to remind the board that I included a suggested condition on that 5.125 waiver for the source as well.
And is that acceptable to you, Mr. Nylander, in terms of your motion, the waiver?
It is, Mr. Chairman.
Okay. We have a motion on the floor. We yet have a second. Do we have a second as to that?
This is Jerry Merritt for the record. I second.
Okay, we have a motion and we have a second. Thank you, Member Merritt. Do we have any other discussion? Hearing none. All in favor, please say aye.
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 Any opposed? Hearing none, the motion carries with the waiver and with the penalty to be worked out as recommended by the board with the Attorney General's office and the licensee. Ms. Connor, thank you for your assistance as to this matter. Mr. Staley, thank you for the work sourcing through this. It does point out some difficulties as we're in our transitional period this year, but it still goes back to the clarity expected by the state of Nevada as to the process. So with that, we'll move our agenda along. We'll move to the items that you wanted to turn upside down on us with Mystic Holding.
Thank you, Mr. Chairman. Before I start on the last items, I did want to mention to the board that I believe a month or two ago, I indicated that I would be able to give you a summary of where we are with our TOI applications. I have prepared a summary for you that I'd like to present on the public record, and I'd like to wait until these items are all, we've taken care of them because they go into my calculations. But after these items are done, I do have a update for where we are with our transfer of interest applications, and I can present that to you at any time during this board meeting.
All right, we will gratefully accept that if you will lead us through our Mystic Holding and the Metafarm.
Thank you very much. Items E, F, G, and H are the TOI applications for Mystic Holdings, or Mystic, and Metafarm LLC and Metafarm One LLC, together Metafarm. TOIs number 19039, 19039A, and 19039B, 19073 were filed by Metafarm and its parent company TerraTech Corp., or TerraTech, requesting approval to transfer dispensary and adult use retail licenses D088, RD088, D106, and RD106 from Metafarm to Mystic. TOI number 19067 has been requested to be withdrawn, and TOI number 20018 was filed by Mystic, requesting approval for a Regulation A filing by Mystic of 50 million shares, or approximately 43% of the company. In addition, Mystic has requested waivers pursuant to 5.112 and 5.125 of the requirements of NCCR 5.110. When we presented these items to the board, we placed them in the order that you would read the Mystic report regarding the Regulation A filing and then finish with the withdrawal. However, I believe that it's appropriate to act on all of the transfers between TerraTech and Mystic before we get to the Regulation A filing, and that's the way I'd like to proceed. So TOI number 19067 is a request for a waiver, what was requested to be withdrawn by Metafarm LLC. TOI number 19067 dealt with the sale of certain Metafarm licenses to an entity called Harvest Health and Recreation, Inc. That agreement was terminated, and the company has requested that that TOI number be withdrawn. With that, I take it back to you. I'm available for any questions. My understanding is that Michael Cristalli and executives from TerraTech and Mystic are present today via Zoom to address any questions you may have. With that, Chair Douglas, I'll turn this item back to you.
I think on that particular item, unless the board member has concerns or questions of you, we can take a motion to accept I guess, do we have to formally take action for the withdrawal, or we can just accept the withdrawal?
I believe our process has been to take action on these, Chair, since they are formal applications.
Okay, then if we can have a motion for the withdrawal as to TOI 19067 for withdrawal. Unless there are any questions or concerns.
Mr. Chairman, this is Member Nylander. I would move that the board grant the request to withdraw in item number 19067.
Thank you. Do we have a second as to that?
Member Durrett, I second.
Thank you. We have a motion. We have a second. Any additional discussion? Hearing none. All in favor, please say aye.
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 Any abstentions or denial? Hearing none, the motion carries. Now we can move, Mr. Staley, as to how you think we should process the others.
Thank you, Mr. Chairman. Item number G is the application by MetaPharm 1 LLC or MetaPharm 1 requesting approval for the transfer of dispensary licenses number D106 and RD106 from MetaPharm 1 to Pixie Reno LLC, a wholly owned subsidiary of Mystic Holdings. I am available for any questions, and my understanding is that Michael Cristalli and executives from TerraTech and Mystic are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll move the item back to you.
At this time, any additional questions of Mr. Staley reference this application? Hearing no questions, it sounds like it would be appropriate for a motion for approval as the TOIs 19039, 19.
No, Mr. Chairman, this would be TOI number 19073, item number G.
Just 19073?
Yes, sir.
Okay. The single item. That's item F in our packets.
Item G in your packets, Mr. Chairman. I'm so sorry.
I have a bunch of paper and it's pointing in different directions. So what we are certain, it's about 19073. With
Yes,
that,
sir.
do we have a motion for approval?
Mr. Chairman, I would move for approval of item G, application number 19073.
With that, do we have a second as to TOI 19073?
Member Durrett, I second.
Thank you. We have a motion. We have a second. All in favor, please say aye.
Aye.
Aye. Any opposition? Hearing none, that motion carries as to TOI 19073 with no conditions. Now, our next one.
Mr. Chairman, we're halfway there. Item F is an transfer of interest applications by MetaPharm LLC or MetaPharm. TOIs number 19039, 19039A, and 19039B have been requested by the company. 19039 is the application for the sale of 19% ownership from each of Second. From each of Camden Gorjan and Richard Von Felt, the sale of their individual ownership to TerraTech Corporation, the majority holder of MetaFarm LLC. TOI application 19039A is an application for the transfer of the remaining 1% held by Camden Gorjan and Richard Von Felt to TerraTech Corporation, resulting in TerraTech holding 100% of MetaFarm. Application number 19039B is for the transfer of dispensary licenses D088 and RD088 from MetaFarm to Pixie LLC, a wholly owned subsidiary of Mystic. Staff identified no areas of concern with this application. I'm available for any questions, and my understanding is that Michael Cristalli and executives from TerraTech and Mystic are present today via Zoom to address any questions you may have. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Any questions of Mr. Staley as to the application of 19039, 19039A, and 19039B?
Mr. Chairman, I don't have any questions. Just a comment that these are sort of related transfers, all of these. So in the future, I think it'd be easier if we could combine these into one item rather than it's sort of messy going through all these individually, but they're all actually related in some way. So just a suggestion, but I would move for approval of these items.
Right. We have a recommendation. We have a motion for approval of these items. Do we have a second as to that?
Member Durrett, I second.
We have a motion. We have a second. I take it we have no additional discussion. With that, all in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries as to TOI 19039, 19039A, and 19039B, which would take us to the Mystic Holding.
Last item, Mr. Chairman, is TOI number 20018, filed by Mystic Holdings, Inc., or Mystic. Application TOI number 20018 was filed by Mystic requesting approval of a Regulation A offering by Mystic of 50 million shares, or approximately 43% of the company. In addition, Mystic has required waivers pursuant to 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. The 5.112 waiver was included in the Mystic investigative report, and the 5.125 waiver was included as a separate addendum to that report. Mystic has adequately addressed the items required in NCCR 5.112 and NCR 5.125, including the addresses of each shareholder, to allow the board to approve such waivers. Staff suggests that if approved, the board limit Mystic's 5.125 waiver to expire on such agenda date as Mystic's next TOI application is heard. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Michael Cristalli and executives from TerraTech and Mystic are present today via Zoom to address any questions you may have as well. With that, Mr. Chairman, I'll turn this item back to you.
All right, we've heard from Mr. Staley. Any additional information anyone wishes or questions of Mr. Staley as to Mystic Holding Inc.? If not, if we can have a motion for approval with the suggested conditions as to 5.125, and I gather we also need to include 5.112.
No, sir, just 5.125.
Thank you.
Mr. Chairman, this is Member Nylander. A question of Mr. Staley. I don't understand why we're attaching this condition on this item.
For 5.125?
Right.
We suggested this condition for waivers of 5.125 so that the 5.125 allows for the licensee to request a time period to be covered by the waiver. And we are suggesting that the waiver be conditioned to expire on the date of their next TOI application, so that we don't just issue a blanket waiver to the company. Again, going back to the continuous or delayed public offering, we felt it was appropriate to give a certain amount of time for the company to operate under this waiver, so that any secondary offering or transfers of shares of less than 5% wouldn't require board approval. However, we wanted the opportunity to revisit whether or not the waiver was appropriate, and we felt that the best date to connect that waiver to would be the next time that they appear before the board. As a result, if Mystic files a TOI application tomorrow, this waiver will only be in place until the next time they meet. If next time you meet and review their application. If Mystic doesn't come before us for 2 years, this waiver would still be in place, allowing transfers of ownership of less than 5%. It was a way to allow the flexibility provided by the waiver pursuant to 5.125, but not making it completely open-ended so that the board wouldn't have the opportunity to evaluate the waiver again in the future.
Great, thank you.
And we have a motion on the floor. We are looking to acquire a second as to this motion for approval.
Member Durrett, I second.
Thank you. We have a motion. We have a second. No further discussion. All in favor, please say aye.
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 Any opposed? Motion carries. Ms. Staley will hold your report to the end. As to this, our agenda.
Great. Chair, thank you, members of the board. We'll now move on to agenda item number 4. This is the consideration of proposed settlement agreements to resolve disciplinary action. Chris Rath, Senior Deputy Attorney General, Counsel for the CCB, will present the proposed settlement agreements via Zoom. Deputy Rath?
Thank you, Director Klimas. Chair Douglas, members of the board, good morning. Christopher Rath, Senior Deputy Attorney General, representing the CCB. We have 5 settlement agreements up for approval at this meeting under agenda item 4. As we've done before, I'm going to go through each of them, provide you with a brief summary and the Attorney General's recommendation for approval. You may then go ahead and ask me any questions that you want, and respondents' attorneys will also be present to answer questions as you need. And then once that's happened, you may then go ahead and decide on the action to be taken for each. So I'm going to go ahead and start with the first one, which is the Cannabis Compliance Board versus Gravitas Nevada, and that's case number 2020-20. This complaint was filed and served on September 22, 2020. Shortly after that, and before an answer was due, respondents' counsel contacted us and initiated settlement discussions. We had a number of settlement discussions, and the Attorney General's office, in consultation with CCB staff, came to a mutual agreement to resolve this matter, which is contained in the settlement agreement before you. The allegations in the complaint concern violations by a medical and adult use production facility in May 2018, so this is one of our older cases. At that time, Gravitas self-reported an incident to the Marijuana Enforcement Division, which was CCB's predecessor. One of their employees had, without authorization, improperly taken several cannabis products home. Unfortunately, a minor at that home had taken the product and brought it to school. MED then undertook a further investigation of the matter. The complaint, which was filed, alleged 3 Category 1 violations for reporting product destroyed when it had not been, and 10 Category 3 violations for allowing diversion of cannabis products. I would like to point out that in addition to self-reporting these issues, the respondent shut down temporarily of its own accord and instituted corrective measures quickly. Paragraph 17 of the settlement agreement summarizes the plan of correction and the correction that was instituted rather quickly. This included dismissal of the key offending employees and suspensions of the other employees involved, as well as additional training for all employees on theft prevention and diversion of cannabis. As set forth in the proposed settlement agreement to resolve the matter, respondent has admitted to 2 Category 2 violations and 1 Category 3 violation. Respondent also agreed to an imposition of a civil penalty in the amount of $52,500 inclusive of costs. The Attorney General recommends and requests that CCB approves the settlement agreement. I'm available for any questions, and I believe we have Respondents Counsel on the line as well, should you have any questions for counsel.
Heard that report. Do we have any questions of our counsel, Mr. Rath? And if the board is inclined to favorably accept the recommendation, if we can have a motion, if not, present whatever questions that need to be presented.
Member Durrett, for the record, I recommend approving the stipulation and agreement, or I move to approve.
All right, we have a motion for approval of this agreement. Do we have a second?
Jerry Merritt, for the record, I second.
Motion, we have a second. All in favor of the acceptance as to Gravitas, Nevada, the settlement recommendation?
Aye.
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 Aye. Any opposed? Motion carries. The matter is accepted. We move to our next item.
Thank you, Chair Douglas. The next item is Cannabis Compliance Board versus Silver State Cultivation LLC, CCB case number 2020-21. This complaint was filed and served on October 20, 2020. Shortly after that, and prior to the due date for an answer, we engaged in settlement negotiations with Respondents Counsel and came to a mutually agreement in consultation with CCB staff as to a proposal for resolution of this matter, which is contained in the settlement agreement. The allegations in this complaint involve a failure to comply with the requirements of disposal of cannabis waste, failure to comply with required documentation on security cameras and a security camera malfunction log, and a failure to comply with sale tracking requirements. As set forth in the proposed settlement agreement, to resolve the matter, respondent admitted to 1 Category 3 violation and 2 Category 4 violations for its cultivation facility. In addition, for its production facility, the licensee admitted to 1 Category 4 violation and 1 Category 5 violation. Respondent, in order to settle this matter, also agreed to the imposition of a civil penalty in the amount of $28,470 for both facilities, which is inclusive of time and effort costs. I would also note that they have gone ahead and paid that time and effort costs. So if this is approved, just the civil penalty portions will be due as set forth in the settlement agreement. Respondent also had provided a plan of correction. A summary of that plan of correction was provided separately to the board members in their packet. This included revising procedures and documentation for cannabis wastage and security cameras and security audits. The licensee is now in compliance. Again, the Attorney General recommends and requests that the CCB approve this settlement agreement. I'm available for any questions. Thank you.
Thank you for that, and thank you for the plan of correction attached. Any questions of Attorney Rath as to this matter? And if the board is inclined to accept it, if we can have a motion for acceptance.
Mr. Chairman, this is Member Nylander. I just wanted to echo your comments. I also appreciate the including the corrective plan as part of the settlement, as we discussed previously, and I would move for approval of this item.
Motion for approval. Do we have a second?
Jerry Merritt, for the record, I second.
We have a motion. We now have a second. With that, any discussion? All in favor, please say aye.
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 Any opposed? Motion carries. That moves us down to Nevada Medical Group.
Thank you, Chair Douglas. The next item is CCB versus Nevada Medical Group, CCB case number 2020-22. This complaint was filed and served on October 20, 2020. After that, and prior to the due date for an answer, we engaged in settlement negotiations with respondents' counsel. And in consultation with the CCB staff, we came to a mutually agreeable proposal for resolution of this matter as set forth in the settlement agreement. The allegations in this complaint concern several violations of respondent allowing employees to work at its cultivation facility without valid cannabis agent cards in their immediate possession. And some employees had made some false statements to CCB investigators. As set forth in the proposed settlement agreement to resolve this matter, respondent admitted to one category 2 violation and 3 category 4 violations with respect to the agent cards and 1 category 5 violation. To settle this matter, respondent also agreed to the imposition of a civil penalty in the amount of $50,000 inclusive of costs. The penalty is the respondent in the settlement agreement has an option to pay the penalty in 5 monthly installments. And if they do choose the installment method, there are significant penalties if a payment is missed or is late. I'd also like to note for this particular settlement agreement, these penalties were imposed under the NCCR, which was in effect at the time of these violations. And that is why the fines are a little higher or are higher for the violations than you would have seen under the NCCRs. Again, the licensee provided a plan of correction for all the issues raised in the complaint and is now in compliance. A summary of that plan of correction is actually provided within the settlement agreement at paragraph 20. It included suspending without pay the employees who were involved in the misrepresentations to the CCB agents, with additional training of all employees and a designation of a separate employee to track agent cards when they expire, and the licensee is now in compliance. The Attorney General recommends and requests that the CCB approve the settlement, and I'm available for questions on this one.
Questions of Attorney Rath as to this proposed agreement? It encompasses a plan of correction. If we have no questions, if we can get a motion for acceptance of this item. Approval.
Jerry Merritt, for the record, I motion for approval.
A motion for approval. Do we have a second?
Member Durrett, I second.
Been moved and seconded. No further discussion. All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Moves us to Medical Cannabis Healing LLC.
Thank you, Chair Douglas. The next item up is CCB versus Medical Cannabis Healing, case number 2020-26. This matter is a little different than the others we've handled before, as it did not involve a complaint. Rather, as you'll recall, the last CCB meeting, November 17th, the CCB had considered a transfer of interest for respondent Medical Cannabis Healing. The CCB approved the transfer of interest contingent on the respondent paying a civil penalty for its failure to notify the CCB of the transfer prior to the transfer taking place. Subsequent to that board meeting, we received word that respondents had considered the matter with counsel and agreed to accept the civil penalty of $4,000 that the CCB had recommended. The settlement agreement before you reflects that agreement. As indicated in the settlement agreement, respondent waived its rights, the filing and service of a disciplinary complaint, and admitted to the imposition of one Category 2 violation for failing to notify the CCB timely of the change in ownership interest. Respondent agreed to pay that $4,000 as a civil penalty, as the CCB had recommended. As such, the settlement agreement simply memorializes respondent's agreement to the terms CCB recommended for approval of the TOI on the September 17 meeting. Therefore, again, the Attorney General recommends and requests the CCB approve this settlement agreement, and I'm open for any questions on this one.
Any questions of this item? This was on, came about pursuant to our last board meeting. And can we have a motion for approval?
Member Durrett, I move to approve.
Motion for approval by Member Durrett.
Jerry
have a
Merritt,
s-
for the record, I second.
Thank you, Ms. Merritt, for a second. Any additional comments or questions? Hearing none, all in favor, please say aye.
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 Aye. Anyone opposed? Motion carries. That moves us to our final item under this. Mr. Alex Rodriguez.
Thank you, Chair Douglas. Our final item is CCB versus Alex Rodriguez, CCB case number 2020-13. This is a disciplinary action seeking revocation of an agent card and a $1,250 civil penalty. The complaint was filed and served on August 25, 2020. We've had several similar ones in the past. There were two key allegations. The first was that respondent was working at a dispensary when he was only authorized to work at a production facility. The events at issue took place on February 21, 2019. Second, video footage from that day revealed that respondent had diverted marijuana by surreptitiously placing cannabis flower into his pocket, which is by itself a revocable offense. The respondent was not represented by counsel. He decided he did want to resolve this matter and negotiated with CCB and its counsel to reach an agreement to settle the case. He was advised on several occasions by CCB counsel that he absolutely had the right to seek counsel to represent him in this and or review his settlement agreement. In any event, the Attorney General's office, in consultation with CCB staff, came to a mutually agreeable proposal with the respondent to resolve this matter, which is embodied in the settlement agreement. As set forth in that settlement agreement, to resolve the matter, respondent admitted to a violation of NAC 453D.365, subsection 3A, which is the diversion of marijuana to a person who is not authorized by law to receive it. As this is a revocable offense, respondent agreed to revocation of his cannabis establishment agent card for a period of 4 years from the date the CCB approves the settlement agreement. Respondent also agreed to pay the $1,250 civil penalty within that 4 years. According to the agreement, if the respondent does not pay the civil penalty within the required 4 years, then the revocation period would be 9 years and 11 months. After the end of the revocation period, whichever one applies, the respondent may apply to the CCB to restate his cannabis establishment agent card pursuant to NCCR 4.030 subsection B. Again, the Attorney General recommends and requests the CCB approve the settlement agreement, and I'm available for further questions on this matter.
Thank you. Any questions of Attorney Rath as to this matter? If we can have a motion for approval.
Member Durrett, I move to approve.
Motion for approval from Member Durrett. Do we have a second?
Jerry Merritt, second.
We have a second from Member Merritt. If the members would signify their approval by saying aye.
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 Aye. Anyone opposed? Motion carries. Thank you, Mr. Rath.
Thank you.
All right, moving on, Chair. Agenda item number 5, this is the consideration of the proposed settlement agreement approved by the Nevada Tax Commission. Chair, members of the board, we have Senior Deputy Attorney General Ashley Balducci, also CCB counsel here. She will be presenting this item. Deputy Balducci. Deputy Balducci, you may be frozen here. But I do know you're close to us. If you'd like to come in here, you're welcome to. I believe I hear her coming now.
Still frozen?
Yeah, we may be looking at you, but that's fine.
Hang on, I apologize. 1 second. Should close out soon. Apologize.
It's all right. Go ahead.
Good morning, Chair, members of the board. I'm Senior Deputy Attorney General Ashley Balducci, and I'm presenting item 5 on the board's agenda. This agreement memorializes a settlement between the Department of Taxation and RadSource Technology LLC to resolve litigation. In the settlement, the Department of Taxation, within 3 judicial days of the effective date, or as soon as reasonably possible after the effective date, will pay $500 to reimburse RadSource Technologies LLC for petitioning the CCB for the repeal and/or amendment of NCCR 12.065 in exchange for a dismissal with prejudice of the litigation. The agreement provides that the CCB shall issue guidance on the applicability of NCCR 12.065 within 21 days of the effective date. The agreement also provides that the CCB has scheduled a public workshop on January 19th, 2021 regarding NCCR 12.065, chaired by board member Dr. Young, and the CCB shall provide public notice to the cannabis industry regarding the public workshop. The Tax Commission approved this settlement agreement on December 7th, 2020. To the extent that the settlement agreement imposes certain duties and requirements on the CCB, it is before the board for approval. Unless there are any questions for me, I will return this item back to the board for deliberation and possible action.
Thank you. Questions of Attorney Balducci as to this matter?
This is Member Nylander. I have a question for Ashley. We've had a number of these in the past. This one's a little bit different in as much as it's coupled with this petition. But I assume that this does not in any way impede our discretion in going forward to be able to consider what Dr. Young's findings are based on the workshop that will occur in January.
That's correct, Board Member Nylander. It does not impede your ability to dispose of the petition within your discretion.
Thank you.
This is Member Young. I had a question and a comment. In regards to the settlement, section 2.3, where it refers to all forms of radiation at any time to treat cannabis, is that going to be the standard for the regulation, or will the workshop maybe leave that open to a different interpretation or a different wording? And can you hear me?
Yes.
Okay.
The understanding is that they've put a petition on for us to look at the regulation, to either, in essence, strike that regulation as it presently exists, or modify the regulation in some way, or in our discretion, we can take no action If in fact, after you have input and have processed this and it's reported back to the board can do what they feel is appropriate, and that might be nothing, but those are all available. But we do have an open canvas, so to speak, to look at this and take the action we think is appropriate. That is all we are promising to do in light of this. I don't know if that's responsive.
Yeah, it actually is. Thank you very much. And then I was just going to make more of a comment. And, this, as I think about this topic in our industry, we have a very unique industry in that we have a product that's used recreationally as well as medicinally. This this product is applied topically, it's ingested, it's inhaled. So it's a very unique product. And so trying to regulate this in terms of the safety of the consumer, which is obviously the ultimate, thing we would want to do here, becomes very difficult with just a few words. So I certainly, I'm looking forward to the workshop and hopefully, diving into this particular issue and seeing what we can do to better to protect the consumer.
Any other questions as to the settlement agreement itself? And then we'll get to our next item, which is what we are doing with this. If we have no other questions as a settlement agreement and our part in this agreeing to go forward with a workshop to look at that in light of the request that was submitted by RAD. If we can have a motion.
Mr. Chairman, this is Member Nylander. I would move for approval of item number 5A, which is the settlement agreement approved by the Nevada Taxation Commission to the extent that it imposes certain duties and requirements upon our board. I would move for approval.
We have a motion by Member Nylander, and we have a second as to this.
Jerry Merritt, for the record, I second.
I didn't mean to cut you off, Mr. Nylander, did I?
I think it was Member Young, but I think he was just going to second.
We
I
have
was
a
just
motion.
going to second, yes.
Motion is second. All in favor of approval, please say aye.
Aye.
Aye. Any opposed? That motion carries. Thank you.
Mr. Chairman, it's rare that we get a third. We got a second and
It's the season to be jolly.
I apologize for my technical difficulties.
I believe that was an excuse to come join us in this room, but
Thank you.
And this seems to be appropriate, the order of our next matter as we transition into area 6.
that's right. So agenda item 6, and these are the petitions filed pursuant to NRS 678A 460. There's 2 petitions. We'll take them one at a time. The first one is RAD source related to the settlement. So here is Deputy Director Michael Miles. He is on Zoom to present these 2 items.
Good morning, Chair and board members. I'm Michael Miles, Deputy Director of the Cannabis Compliance Board. Before you today is an NCCR 4.145 petition from RAD Source Technologies Incorporated, who provides equipment to some licensees that can be used to decontaminate post-harvest cannabis using ionizing radiation. They are requesting relief from NCCR 12.065. Currently, NCCR 12.065 requires that cannabis or cannabis products treated with radiation must be labeled with a notice to inform purchasers of said treatment. Presently on Zoom is a representative of RAD Source Technologies, and they're available to briefly summarize their petition at the board's request and answer any questions the board may have. CCB staff is also available to answer any additional questions from the board. With that, Chair, I turn the petition back to you.
Thank you. With that said, this is an item that has come to us in public comment a little bit. This lawsuit, it was before our predecessors squarely put this in front of us. We've agreed to look at this and see what information is available. RAD Source submitted a petition. If RAD Source is available, we'd like to hear from them as to this matter.
Thank you, Amber. If you would unmute, representatives of RAD Source. I know we have Ms. Maxine Rushton and individuals from the Rad Source Company. Hello, Ms. Rushton, can you hear us?
Yes, I can. Good morning. Good
Morning.
morning, Chair Douglas, members of the Cannabis Board, Administrator Klimas. I'm Kimberly Maxon Rushton with law firm Cooper Levinson, appearing on behalf of Rad Source Technologies, Inc. Joining me today are Mr. George Terry, the Executive Vice President of Rad Sources Technology, and Mr. Joel Schwartz, Litigation Counsel for Rad Source Technology. Chairman Douglas, as noted by the Deputy Attorney General, by Mr. Miles, the matter before you is a petition in which RAD seeks to have Regulation 12.065 repealed. Specifically, RAD submits that the regulation imposes an unnecessary obligation on licensees to include a notice which is not scientifically based and has the potential to mislead the public that certain cannabis products may be unsafe. That simply is not true. I'd also note the fact that there is a governing statute, specifically NRS 678D.420, which specifically speaks to the applicable labeling requirements imposed by the legislature specific to cannabis products. There is nothing in that regulation or in that statute or any of the other statutes which allows or authorizes the additional labeling requirement that exists currently in Regulation 12.065. As set forth in the settlement agreement, the parties have mutually agreed that we would proceed to a workshop hearing on the regulation, thereby allowing us to present information and also staff as to the basis for why 12.075 was ever intended for regulation and then subsequently adopted. I'd also like the opportunity, Chair Douglas, to respond to Member Young's question specific to the settlement agreement in Section 2.3. That specific provision, Dr. Young, was a request or an agreement between the parties whereby the Cannabis Board would notice the industry that 12.065 as it currently exists is applicable to all forms of radiation, not just irradiation. And so for those reasons, I would respectfully ask that you grant the petition, recognize the requirement in there relative to the notice, and therefore proceed to a workshop if necessary. Otherwise, again, our request is that the regulation be repealed. My client, Mr. Terry, is on the phone if you have any questions, or I'm happy to answer any questions the board may have.
Thank you. Board members, any questions of Ms. Rushton? All right. I think that this gives us a great opportunity. The labeling issue has come up a number of times in other fashions. It gives us an opportunity, as was stated, to look at this, see if this is appropriate or not appropriate, the reasons for it, whether they were good, whether they were bad, and what is the appropriate thing to do. I'm very thankful that Member Young, who has an MD beside his name, has decided to take up the heavy lifting, so we appreciate that. On this particular item, I have a side proposal within that. We had indicated that we would have this back in January for the board. I would still like to see it come back before the board for an executive summary of information received. And then we would place it on our February agenda after receiving that kind of summary to take whatever action is appropriate, whether it is repeal, whether it is altering, whatever it be. And as Ms. Rushton said, the notice would go out to the industry as to the use of the regulation in the interim. But having said that, that's my only comments. Other board members wish to engage or ask questions of our counsel or Ms. Rushton at this time.
Comments from me.
Chairman, I have a comment, just that I'm glad we're headed in the direction that I don't think this needed to go to litigation, because we ended up back in the spot where it should have been, but it wasn't possible under the Department of Tax. They didn't have this petition process, and the CCB adopted that. And so this is, we can avoid litigation in the future by just starting with the petition process.
Well, it went to litigation. A mandamus was issued by the court. This ends the litigation, even though the restraint of that litigation is still in effect. as to this individual. But more importantly, it brought forth this petition to look at what we have and make a correction if correction is needed. And that is for the workshop and Dr. Young's group, and to bring it back. And then for us to fashion something to do thereafter. Other questions or?
Mr. Chairman, this is Member Nylander. I guess what the petition's been filed. I guess what we're being asked to do is just accept the petition. Is that correct?
To grant the petition in part, to go ahead with the workshop. It doesn't obligate us on the end of it, but we're saying we're going to look at this and then make a decision as to what we're doing with the regulation. And we do understand what was done by the court as to this particular applicant and the mandamus, which is limited to this particular applicant, and what was done at the time.
Understood. Thank you for that.
So if there's no additional questions, and Dr. Young, you are going to be challenged with the heavy lifting. I, for one, would propose the acceptance. We would grant the petition in part. And the board can set the item for an executive summary at its January 26, 2021 Cannabis Compliance Board meeting and allowed for consideration of information presented at the workshop on NCCR 12.065, which has been scheduled for January 21st, if I'm correct.
January 19th.
January 19th. All right, 2021. And thereafter, we would take whatever action is appropriate at our February meeting based upon this. And additionally, as was indicated, we will provide information to the industry as to the effect of the prior regulation. I'll make that in form of a motion.
I would second that motion, Mr. Chairman.
And I thank, not part of the motion, thank Dr. Young for accepting this challenge and to give us guidance. With that, all in favor of going forward with this position, granting the petition in part as was indicated, please say aye.
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 Any opposed? Hearing none, that motion carries. Thank you very much. Move to our second item under this category.
Good. Once again, good morning, Chair and board members. Again, I'm Michael Miles, Deputy Director of the Cannabis Compliance Board. For you today is another NCCR 4.145 petition from Blackbird Logistics, who holds 2 cannabis distributor licenses. They are requesting relief from the 2-driver rule under NCCR 13.025 subsection 5 due to the current emergency situation with COVID-19. Currently, NCCR 13.025 subsection 5 requires 2 cannabis establishment agents to accompany any vehicle that transports more than 25,000 worth of cannabis or cannabis products. Presently on Zoom is a representative of Blackbird Logistics, and they are available to briefly summarize their petition at the board's request and answer any questions that the board may have. CCB staff is also available to answer any additional questions from the board. With that, Chair, I will turn it back to you.
Thank you. Do we have our representative who presented this petition to us on the line?
So Amber, please unmute Mr. Condor and Ms. Gallerani if they are joining us.
Good morning, board members. I am here. Can you hear me?
We can.
Thank you. This is Jennifer Gallerani, the Director of Compliance for Blackbird Logistics. Happy to answer any additional questions beyond our petition or summarize if you need me to.
All right. Um, The petition seems to want to get down to a single person because of the COVID factor. Is that a correct assumption to make?
Yes, so we submitted a petition with two options or two recommendations for the board to consider. The first of which is more of an emergency action request for relief of the two-driver rule during the coronavirus pandemic, to immediately waive that two-driver requirement as to assist from keeping our employees in closed cargo vans for a prolonged period of time. We have had instances of COVID positive test results in California, which has had detrimental effects and complete closure of some of our arms of distribution in that state. In Nevada, we have been lucky, but we are trying to prevent a situation where one employee with a positive case would effectively shut down the majority of wholesale distribution in Nevada. The second recommendation is more of a consideration to waive this requirement in perpetuity. And we walk through in our petition some of the reasoning as to why we feel the two drivers does not present additional security benefits. And we feel we could be having a single driver requirement for any load value in parity with anything like tobacco, alcohol, or high value electronics.
Thank you. Board members, any questions? Yeah. Myself personally, I would be looking at this in light of our COVID concerns as an imminent health hazard under 4.0651 small I, that we suspend the two driver requirement for a time period and only mandate one person until our February 23rd meeting. And at that time, we would consider what is appropriate, whether or not we need to continue the suspension of the two driver or whether we take this limit back off, or if something else needs to be looked at. And I would put that.
Mr. Chair. I apologize, Mr. Chairman. This is board counsel.
Yes.
I just wanted to state one thing for the record, just for the board's clarification, that what's being voted on right now is to just schedule the matter for action pursuant to NRS 678A.460 subsection 1D. So we're just scheduling it, and as you noted, suspending the enforcement of the rule until that hearing.
That's correct.
Mr. Chairman, this is Member Nylander. I'm in agreement. I don't know about this notion of having another vehicle follow on. I guess I'd like to hear the applicant's comments in respect of that.
At this time, there's no secondary vehicle following our distribution cargo vans. There is a requirement to have two drivers in a cargo van with a wholesale value of product that exceeds $25,000. Because most of the wholesale value orders in the state of Nevada exceed or are approximately $12,000, and we load several orders into one cargo van, that equates to approximately 80 or 85% of our wholesale deliveries required to be done with two drivers in one enclosed van. There's no security tails or anything like that. And we haven't seen the need for that. When we do wholesale deliveries, the security factors happen on loading and unloading. All of the loading is done in our secure, at retail locations and secure areas under camera and under security guard. While being transported to the final destination, there is no security guard or need for security guards. We would argue that if ever we were targeted for a robbery while in transit, that those robberies would be targeting the cash on hand. There's no evidence of cargo van jacking per se. And, you know, we've outlined in our petition some other details in terms of what magnitude of values we've been transporting for context. Approximately 50% of our routes have more than 50,000 in product, and about 10 to 15% carry over 75,000.
Very good. So, and I've obviously reviewed the details in your petition. Is it fair to summarize that you don't see any appreciable benefit from a safety perspective of having a sort of a shadowing vehicle behind the actual transport vehicle?
Correct. There, in our opinion, there is no need for additional security while in transport. I think all of the security requirements at loading and unloading are everything that you need to protect those goods.
Great, thank you.
This is Member Young. I had a question. When the product is loaded into the cargo van and it's locked, does the driver have access, or is that he does not have access until it gets to destination?
The cargo vans have a secure cargo area, so you would have to access it under lock and key. Once you get to the destination, they wouldn't be going into the cargo van from the driver's seat.
But does the driver have access, or only someone once they reach the destination?
Now, the driver has the keys to the cargo van and has access to the cargo.
So I guess this would, for me, would lead to a second question. Is the purpose of the two driver rule to protect the product from a third party robbery, like you mentioned, like a carjacking, versus theft from an employee, the driver, or the person? Is that the intention of the two driver rule? Maybe someone could help clarify that for me.
I would defer to the committee for that response. And for context, just from a psychological perspective, we would argue that if you have two drivers sitting in a cargo van, you may have more opportunity for them to be in cahoots and come up with a strategy or an alibi situation rather than a single driver.
Member Young, this is Tyler Kleinis. Yes, this rule is in place for security reasons. That's the reason that the two driver rule is there. Contemplating not only transport, but also stops along the way, having a backup there with the driver is in place just to ensure that there's an extra level of security and safety.
So I would propose, or I wouldn't say propose, but question, if we move to the one driver, should there be some sort of secondary security measure in terms of like an internal camera in the car or some other way to view the product so that there's no chance for the driver to, have for a theft issue from the driver? I mean, I think it would be more difficult for two drivers to be in cahoots, so to speak, than it would be for one person to, steal the product.
At this time, we were merely looking at what has been proposed, which is suspending the regulation for a limited period of time due to COVID, not the security concerns you're bringing up. If we wish to go further, we can do that at the next meeting or take whatever action we think is appropriate as to reinstating it, not reinstating it, but it would come to an end, continuing it, or looking at a possible new regulation.
Thank you, Chairman. I do agree that, for the COVID purposes, that minimizing contact is essential.
Thank you. If there's any additional information that we can provide or summary of explanations regarding internal diversion risk or internal theft risk, we're happy to provide that. Our petition mostly focuses on external theft risks and how our drivers are trained to completely acquiesce to any kind of theft risk and not fight anybody trying to take cash or product. Happy to look into research or summary documentation about internal risks as well.
Okay. I've put a motion on the floor for suspension based upon the imminent health hazard under 4.065.
This is Member Young. I would second that motion.
Been moved and seconded. No additional discussion. All in favor, please say aye.
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 Any opposed? Motion's carried. That moves us down to number 7.
That's right. Chair, members of the board, agenda item number 7 is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting took place. We have one license to note today for the board, in Development Company, Inc., RD 215, located at 4850 West Sunset Road, Suite 130 in Las Vegas, Nevada. The final inspection was conducted on August 11th, 2020, and CCB inspection agents noted no deficiencies, deeming it in regulatory compliance. The final license number was issued on November 18th, 2020. With that, Chair, members of the board, I'm happy to answer any questions.
Any questions by board members as to this matter? It's on for information. Hearing no questions, we can move to our next item.
So the next item, this is agenda item 8. This is the briefing of the board from the executive director. Chair, would you like Chief Staley to go ahead and give his summary of the TOIs? It's kind of in line with some of the things that I'll talk about as well.
Why don't we do that and then let you wrap it up thereafter.
Great. Chief Staley, do you want to go ahead and give your wrap up on the TOIs?
Yes, sir. Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I'm David Staley, Chief Investigator for the CCB. As you're aware, on October 11th of 2019, the Department of Taxation instituted an extended review period by indicating that the Marijuana Enforcement Division would not process any new or existing transfer of interest applications or TOIs until it could complete a more thorough and appropriate vetting process. On July 21st, 2020, you lifted that extended review period and directed CCB staff to begin processing TOI applications. As of July 21st, 2020, there were 92 outstanding and distinct pending TOI applications, or about 55 if you consolidated them by parent companies. These were placed on hold when the extended review period was put in place. In addition, during calendar year 2020, another 30 to 35 TOI applications have been submitted. CCB staff began submitting TOI applications to you for consideration at your August 2020 meeting, and since then, you have acted on the following. 28 of those TOI applications that you acted on were from the extended review period. An additional 13 came out of the partial settlement agreement from the licensing lawsuit, and that lawsuit required that we act on them as expeditiously as possible. So those 13 were moved as quickly as they could into an agenda item for you to consider. And then there were additional 9 that we pulled from the 2020 applications. Some of them were attached as additional requests to the settlement agreement TOIs. Some were administrative cleanup type applications, and some we acted on due to pressing time limitations for individual stockholders, such as one stockholder completing estate planning during a terminal illness. In addition, CCB staff has begun processing another 21 TOI applications from the extended review period, but we have not completed our review for various reasons. 5 have been placed on hold at the result of the applicant or due to pending litigation that impacts that TOI request. If my math is correct, that means that staff has completed 50 TOIs and submitted them to you for action since August, and staff has completed or started 49 out of the 92 TOIs impacted by the extended review period, which is a little over half. 38 of the extended review period TOIs have not yet been assigned, but we anticipate assigning them during the first part of 2021. I anticipate that most of the old TOIs will be completed by mid-year, and we should have a much smoother process in place to handle the TOIs as they come in. None of this progress would have been possible without the extraordinary efforts of your staff, who routinely work after hours or weekends to get these applications processed. In fact, I'm not aware of any CC staff in any area that do not routinely work extra to complete investigations, work cards, or audits, and I'm very proud of our entire team for their efforts. I'm available for any questions you may have on the TOI process.
Board members, any questions you may have of Mr. Staley? Hearing no questions, thank you for that update.
Thank you, sir.
Great. We'll move on. And for my report this month, I'd first like to just give an update on agent registration cards, which I touched on at the last board meeting. To update you, we have continued to make considerable progress working through the agent registration cards. Our numbers look very good and continue to trend in the right direction. And we are currently processing same-day applications as we sit here today. Outside of our control, there remains the time it takes to mail in a payment. That's 7 to 10 days before we can finalize any application. But in most cases, applicants are receiving their temporary agent card, which allows them to begin working in the industry immediately on the same day that payment is received by CCB staff, as long as the application is complete. That is a far departure from where we were just 6 weeks ago, and a testament to how hard staff has worked to ensure the CCB is caught up on the delays caused by COVID and the transition from taxation. Now, moving forward, as we continue to work to streamline this process, we've received approval from the Nevada Controller's Office to implement revolving accounts, which we plan to roll out a pilot program with a number of licensees very soon. This will allow a direct drawdown from an established account, providing for same-day payment on applications requested by an establishment. Additionally, we've been working on implementing ACH payments, which would allow for online payments from a checking account. We are targeting the beginning of the year to implement that process. So in short, we've taken a number of steps to speed this process up, to realize efficiencies in every corner of the process. We appreciate the feedback we've received from industry as we work to make this system one that works for everyone. Now as we move forward with closing out the year, Chair, I'd like to take this opportunity to reflect a little bit about the last 12 months and certainly the last 6 months as the CCB proper. Given where we've come from, I'd first like to thank the industry for its patience and willingness to adapt, as Nevada has now implemented its third iteration of cannabis oversight in this state. This iteration, the CCB, has brought many changes to operations, to engagement, to overall ways that we regulate. I have seen that the industry has worked hard to be flexible, to understand some of the new ways that we do things, and to buy into the public policy direction passed by the governor and the legislature, ultimately governing how this body is supposed to work and how this industry should be regulated. I appreciate the industry for being willing to come to the table to discuss issues when they arise respectfully and work to find solutions. So at the end of the day, this industry and this state continues to prosper, to find ways to be fair and equitable, and to be led by strong, diverse individuals that keep the well-being of this state and its citizens in mind. Could have not foreseen the challenges this year brought us, both as regulators and as members of the industry, facing a global pandemic that no one was prepared for. However, as it stands today, what has remained at the end of 2020 is an industry already experiencing amazing growth, pivoting its operations, working with its regulators, and now, frankly, sits atop the list of industries in the state of Nevada that have proven its essential status, maintain jobs for its employees, maintain compliant operations, and continues to provide a revenue source for a state that desperately needs it. It's the partnership between the regulators and the industry, the commitment to compliance, the collaborative understanding that our goals are shared that will continue this into the new year. And finally, Chair, members of the board, I'd like to acknowledge and thank the CCB staff. Their work over the last 12 months has been remarkable. The amount of work and time these individuals put into their jobs, the commitment they show to each other and to the work we do as a group is well beyond anything I could have expected. I feel lucky to be able to lead this team, to learn from this team, to watch this team work with each other and grow, to tackle issues, to make mistakes, to correct mistakes, and to leave it all on the field every day. It is without question in my mind, this year belongs to the staff of the CCB. They make it happen day in and day out. They work hard for this industry, harder than I think most know or give them credit for. I'm proud to work alongside every one of our 46 team members, including our partners at the AG's office. I thank them for their incredible dedication and effort to build what will be the gold standard regulatory body. So with that, Chair, let us please put an end to this year, and I'll conclude my remarks and turn it back over to you.
Thank you. With that, I note that our next meeting date is January 26th in the year 2021, which is an amazing statement of 2021. With that, I'd just take a brief minute to say thank you to the cannabis compliance staff for their hard work, their due diligence to make this year of transition from the tax to the Cannabis Compliance Board what I would consider a successful year. Their hard work and going the extra mile is greatly appreciated, and even more so because of the cannabis situation, which has brought stress and created some problems, but this group has worked to overcome them. They've also been saddled with this brand new board, which was authorized beginning of the year, but our first meeting was in July, seems just a minute ago. To my fellow board members, thank you for your work, your cooperation. The new heavy lifting that's been picked up by Member Young and Member Durrett. And I'll come back to Member Durrett momentarily. 2021 hopefully will be a year of hope, of great expectations for us, that it will be much better than 2020 for all of us, the staff members of Cannabis Compliance, as well as the board and our families. 2021 in Nevada, since we are a state that's blessed or burdened with legislature every other year, will be a legislative year. And so in January, the bills will be dropping like snowflakes or rain, which we are not used to in Nevada, at least in southern Nevada. Member Durrett, hopefully in January, we can get kind of some update of what we're looking at legislatively from the industry, since you've taken your time to meet with them, with our director, to kind of get an overlay of that. And hopefully we can get a follow-up of what's been dropped from the legislature in the early going. But again, this is a season to be thankful for getting through this past year without too many hiccups and scratches, and to pivot at Christmas and look for hope for the next year. So with that, unless there's anything else to be added, thanks to all, thanks to the board for being so cooperative and willing to go the extra mile reading the information to move the industry along. And do we have any public comment to be added to this before we close out?
Chair, we have no public comment.
With that, we are in adjournment. Thank you very much, and happy 2021 coming.
Happy holidays.
Happy holidays.
Happy holidays,
Thank you very
everyone.
much.
Thank you, Mr. Chairman. Thank you, board members.
Thank you. Happy